Good afternoon, everyone. This is Attorney Elise Gross with the Presser Law Firm for today's webinar. We're just waiting for the last of the people to sign on, so we will come back in about a minute or two.
Also provides you with estate planning services. When developing an effective asset protection strategy, you also must look at your overall financial picture. The Presser Law Firm PA can integrate your asset protection plan with your present estate plan or work with you or your attorney to create a new estate plan. We provide probate and estate administration, review of current estate plans, as well as draft wills, trusts, power of attorneys, healthcare surrogates, living wills, and designations of guardians. We can also assist you in the areas of business, incapacity planning, and taxation. We'll be glad to schedule a complimentary preliminary consultation for you today. Thank you for holding. If you don't keep your asset protection plan current, it's useless.
Good afternoon. Today we're going to be speaking about using entities in your business. I just want to give you a little bit of background information. I am Attorney Elise, law in South Florida for over 20 years. My practice is basically asset protection and estate planning. We do webinars once a month, one on asset protection, one on estate planning. So if you're on today and you like what you hear and you'd like to hear others, please tune into our newsletter that we send out once a week, and that'll give you all the information about upcoming webinars. If you know of someone who's interested in getting our newsletter who's not already doing it, they can reach us at info@assetprotectionattorneys.com. We also do preliminary complimentary consultations for anyone who has any legal needs, so they can give a call in and be set up to speak with one of our attorneys. And our attorneys are all qualified speakers who give webinars and do speaking engagements. So if you're interested in a topic, then it's possible that you can get a group of people together and we can try to set something up for you. So anything you need, you can give us a call at the office or contact us via our website, www.assetprotectionattorneys.com, or during the course of this webinar with any questions, info@assetprotectionattorneys.com. At the end, we're going to do a question and answer period, so you can just email those questions in. Again, today we're going to be talking about using business entities for asset protection. I'm going to give you a little bit of a background on what asset protection is before we get started. We're going to talk about asset protection basics today, why you should form an entity for your business to protect it, a bit of an overview of the different types of entities that we use for forming businesses and asset protection, and how you actually might use multiple entities for your business. And then we'll briefly discuss where an international entity may or may not fall into your business plan. Asset protection is how you title your assets legally and ethically in order to protect them from future potential creditors. It doesn't matter how much you have in the way of assets. It's a question of whether or not you want to protect them. You may have a client who has $100,000 or a client that has $100 million. But it all comes down to what is the client's risk level and what is their interest in protecting what they have, and based on what exemptions are available in their state as to whether or not they're looking to do an asset protection plan. People that come here, some of them already have some sort of asset protection plan in place. And what we do is we evaluate each and every client just to make sure that what they have is the correct plan, and if they need anything additional in order to make it more sturdy of a plan. Majority of people don't already have something in place, but even if you do, you always want to have it reviewed periodically to see what, if anything, needs to be changed. There are over 100 million lawsuits each year, and that number is growing, with a 1 in 4 chance that you're going to be sued in the next year, at an average of about 5 over your lifetime. Those are some pretty heady statistics. So, it's important to make sure that you come in to a qualified asset protection attorney just to make sure that you've kind of evaluated what your business does, what your personal situation is, just to see what your risk level is and what you may need to protect that's not protected. There's also an over 50% chance of divorce. So when you do your planning, you can't specifically plan for divorce because that just doesn't usually work, but it doesn't mean that you can't pre-plan before you get married, or even, kind of strategically put your assets into, proper titling to make sure that even if there is a divorce, you still do okay. And then, most people don't realize that just being sued is going to cost you, not just in money, but in time and in aggravation and the emotion that's involved. So even if you are 100% in the right and somebody frivolously sues you, it's still going to cost you. You're still going to have to pay the lawyer. You're still going to have to participate in depositions and go to court and do whatever else needs to be done. Yeah, maybe you might see that money back again if you're able to get attorney's fees from the plaintiff, but you'll never get that time back and that aggravation back. So you always want to have a plan, because that way you know that you can protect at least somewhat against potential creditors. We love liability insurance. It's a wonderful thing. It should be your first line of defense. Anytime you can have liability insurance, it's usually reasonably priced. It's a great way of putting a barrier in front of your assets for potential creditors. However, it's not the ultimate plan. 70% of lawsuits aren't even covered by insurance. Insurance basically is in place to collect money, hopefully to cover you, but the reality of the situation is, on a statistical level, when you file a claim, insurance companies are not jumping to pay the claim. They probably have some sort of statistic as to what they accept and deny on the first round. You always have to keep that in mind. So it's wonderful to have. Definitely it's a great way to help you sleep at night, but you can't rely upon it 100%. Even if you have insurance, that insurance might be inadequate. It may not be enough. Maybe you have only $100,000 of liability coverage on your vehicle in case of an accident and somebody gets killed and there's a multi-million-dollar judgment. So it's great you have the coverage, but it's not enough. Your insurance company might go bankrupt. It's happened. If the insurance company is not one of the ones that's insured by the particular state or by the federal government, it may not pay. And if they go bankrupt after a good storm, you may, or for some reason, you may not get your claim paid, even if it's completely legitimate. And then finally, there's some things that insurance can't even cover, that they don't even have insurance for. Divorce, certain other financial risks that are so risky that an insurance company won't even cover it. So while insurance is wonderful, it is definitely a good thing to get. Don't let it be your complete safety net. You always want to protect yourself before you have a problem. After you have a problem, you are limited in what you can do because there's fraudulent transfer statutes. So if you make sure to have everything evaluated, how you own things, prior to ever having a creditor, then you'll be in much better shape than the person who comes in after they have a creditor, because they will be severely limited in what they can do and whether or not even doing the plan would be able to protect them long term. It doesn't mean that you have to have a very complicated, intricate plan. What you do is you start out with something basic, and then as time goes on, you can build upon it depending on what your assets are, the things you accumulate, what type of business you might be in. So you always want to just start early, start with the basics, and then you build it up. Don't look at your neighbor for what plan your neighbor did, because it may not be the right plan for you. You always want to have yourself evaluated individually, because your assets, your family situation, your business situation, your partners, that's going to be different than your neighbor. That's going to be different than your brother. Sometimes it might be a similar plan, but most times you have to look at each person individually to determine what is appropriate for them. A few things you definitely want to avoid. Number one, hiding. A proper legal asset protection plan is not about hiding. You have to assume that at any point a creditor who gets a judgment against you is going to get full disclosure in a sworn deposition. So it's never about hiding. If your goal is to hide, then you're not doing things properly. It doesn't mean you can't get some anonymity, and I'll mention that a little bit later, but you're never hiding anything. The IRS always knows what you're doing. Your CPA always knows what you're doing. So it's never about the hiding. You also don't want to title your assets to straws. So what is a straw? A straw is where you put assets in the name of another person who is not you, with the theory that if you don't own it, well then your creditor can't get at it. It's an interesting theory, and it could work in some situations, but the problem is, number one, what if the person whose name you put it in gets sued or has a divorce? Then there goes your asset because they own it, you don't own it. And two, what if the person whose name it's in you fall out of favor with, and when you want it back, they're not going to give it back to you. So that doesn't work. Same with titling assets to your spouse. I've seen it a lot, mostly in the medical world, where the doctors will say, well, everything's in my wife's name, it's not a problem. Well, it is a problem because the wife's out driving a car, the wife might have some other liabilities and might get sued, and now everything's in the wife's name, and now it's going to be gone when the creditor comes. Number two, what if there's a divorce? You've just helped the wife's situation because now everything's already in her name. It's going to be a lot easier. And thirdly, there's something called tenants by the entireties, which is available in about 25 states, where if you actually own the property with your wife, then you have some advantageous creditor protection with that type of ownership. Fraudulent transfers, which I mentioned a little earlier, that's a civil issue. It is not a criminal issue, at least the way we discuss it. The fraudulent transfer is where you have an existing creditor, you transfer assets out of your name for the purpose of avoiding paying that creditor. That's a very simplistic explanation to it, but the idea is plan beforehand so that you can avoid these fraudulent transfers. If a judge decides that you did a fraudulent transfer, then whatever you did can be reversed so that the creditor can be paid. So you don't really want to be in that situation. And lastly, probably most importantly, is no matter what you do, never break the law to do it. The thing is, if you can plan ahead and make it strategic planning, then there's no reason why you can't do everything legally and ethically with full disclosure if you ever needed to, and still protect those assets. So why set up an entity for your business? Well, it used to be 100 years ago that people would just start a business. They never incorporated, and they started a business in their own name, and they were sole proprietors. And then the corporations started coming to being, and eventually the partnerships, and then finally limited liability companies, which came along really only a few decades ago. You never want anything in your own personal name, because if somebody gets a judgment against you personally, well then that's easy. They can always take whatever you own. So we always suggest that if you're going to have a business, it has to be in some sort of entity. And we're going to talk about the different choices today. You want to do what's called personal asset protection, which means you want to protect your own person, your own self, if you get sued. And that might be from an outside person if there's a car accident, a business partner if you are in business, someone, a family member, which happens all the time. It could be any type of lawsuit. You don't pay a debt. That would be personal asset protection. How do I protect myself against a personal judgment? So if you own your business in an entity and you own it correctly, then if your business has a problem, then they can't really get at you personally. Having your business set up in an entity versus in your own name adds some credibility to the business. When you see a company, when you see a business that's, Joe Smith, as opposed to Joe Smith Engineering LLC or Inc., it makes a big difference. When I think I'm dealing with just one guy who doesn't really have a corporate structure behind him, I don't know, most people feel that, they'd rather deal with the company. And a lot of it is a mindset, but it does make sense. If you have a corporation or an LLC or whatever it is that's going to be protective, the fact that it's in that entity name and not in your own name is going to protect that asset because it's not just in your personal name. And then actually name protection can go two ways, because if you have it in the name of an entity, you can actually protect the name itself of the corp. IBM can protect its name. There's laws that allow you to protect the actual name and the branding of the entity itself. Perpetual existence. That's the company actually can exist long after you. So if you created this company, if you develop a business and it's just in your name and you die, then, or you decide to retire or get out of the business, then there's really nothing left. But if you have a company that's created, that company can exist way beyond you. So it has better benefits for your family ultimately, and possibly for you if you're retiring and you're maybe getting some income from the company itself. And then finally, there's always some tax benefits to having company ownership because of things that you can deduct and certain tax benefits that might be available to the particular entity. The types of entities that you see out there, and some are better for asset protection and some are not, let's talk about those. The first one that we use a lot is a limited liability company. And I told you that one really has only been around for several decades. But what that is a company that has members. The owners are called members. And it's either managed by the members or it's managed by managers, which we prefer. And in that company, if somebody sues the company for something done in the company, they cannot get a personal judgment against the members or the managers of that company. So for instance, let's take something, the vacuum cleaner business that's in an LLC. We sell a vacuum cleaner that is faulty and somebody gets hurt. It was certainly not an intentional thing. It was a product defect. And somebody gets hurt and they sue. Well, they're going to sue the company and they'll be entitled to a judgment against the company and the company's assets. But they won't be able to sue me as the member or me as a manager. So that's a great insulation of liability, and that's one of the main reasons you do an LLC. It may not be the best for tax purposes, so anytime you set things up, it's important to make sure your CPA is involved in the whole process. It can work. We're going to talk about how certain entities can work together a little bit later on. But an LLC is great for liability protection. Professional liability, limited liability companies, or PLLCs as they're called. In other states they're called different things. I think California it's called a registered limited liability company. Essentially those are for specific professional practices, law, medicine, architecture. I can't think of any more at this point, but you're only allowed to do them if you fit into certain categories. So that might be something you would do if you are a professional. You would set up what's called a PLLC. Not every state has them, so you need to know what your state laws are in order to know if you qualify for that. Otherwise, it might be just an LLC. Your C corporation and S corporation. The difference here is that if operated properly, a corporation can also insulate its shareholders from liability. C corporations generally more than S corps, because in a C corporation, there's usually a lot of owners with different amounts of shares, and it's usually run by some officer, president, CEO, CFO, whatever it is, and the owners, the shareholders don't really have any participation in the company. So if somebody sues the company, they're not likely to be able to get at the shareholders. We're going to talk about why that's not the greatest asset protection, but in order for you to insulate from liability, I would say it's not such a bad thing for a C Corp. The S Corp is a little more pickly because the S Corp, while technically is supposed to insulate the shareholders from personal liability, and an S Corp, because it's usually a closely held company, it's usually run by the individual owners, which means that you kind of muddy the waters in terms of personal liability. I see it very often where there's an S Corp, where if there's a lawsuit against the company, they go immediately after the owners/officers of the company. The reason I said that they're not the greatest for liability protection, like an LLC, is because if you have an LLC and someone sues you personally, gets a judgment against you, they, depending on the jurisdiction that it's formed in and those laws, can't take your LLC interest, which means somebody gets a judgment against me for a car accident. I have an LLC. My LLC may be worth $5 million, my interest. The judgment holder from the car accident cannot take my LLC interest. They can't look at the corporate books. They can't take over ownership or control of the LLC. Whereas in a C Corp or an S Corporation, if you're the majority shareholder, they can take your shares anyway, no matter how many you have. But if you're the majority, they can take over by having your shares. They can change the operations of the company. They can take over instead of you and the corporation. So you have to be very careful. And we see S Corps are very common. CPAs love them for tax reasons. So we see a lot of clients who've had S Corps in existence for a very long time. We can work with them, but it definitely limits the type of planning that can be done. So that's where they come in as entities working together. The last type of ownership is a partnership, and there's definitely several different ways that you can go with a partnership. The first one is your standard partnership, which is a general partnership, where you and I go into partnership together, and we share 50-50 in the profits, we share 50-50 in the losses, we share 50-50 in the liabilities. That's a general partnership. You have no insulation of liability there. Everyone who owns is liable. They're considered general partners. Contrast that with the limited partnership, which is where you can have as many limited partners as you want. Between them, they can own the majority of the company, but they have a designated general partner who's responsible for the debts and liabilities of the partnership. So it might be an individual, it might be a company that's the general partner, but essentially the limited partners have no control. They also have no liability. Definitely sounding better than the general partnership. You also have a couple of newer type of structures, which are called a limited liability partnership, which is similar to the general partnership, except that each partner is only liable for their own actions and not for the actions of the other partners. You might see this with CPAs and with attorneys, architects. In a professional sense, you might want to do this, because if everybody is performing in a professional capacity, why should they want to be liable for the guy in the next office's problems? And then lastly, we're starting to see a lot of these is the triple LP, the limited liability limited partnership. It's similar to a limited partnership, but it's kind of a combination of a limited partnership and the double LP, the limited liability partnership. The difference between the triple LP and a traditional limited partnership is in the traditional limited partnership, the general partners are jointly and severally liable for all debts and obligations of the partnership. And then in the triple LP, essentially you can almost insulate all partners no matter what, even the general partner, from liability. You're starting to see more of these things. There's different requirements for them. Not every state allows them. Ultimately, they probably will, but right now it's a much newer entity. I covered actually a lot of this on the other slide, but basically when you have a corporation, you have less asset protection because anybody can get your corporate shares if they have a judgment against you personally. If they have a judgment against the company, on the C Corp, highly unlikely to be able to get at you personally. On an S Corp, while it's not supposed to allow you to be hit personally, I wouldn't hold my breath on that one, because in an S Corp, their chances are they're going to sue you personally if you are running the company. And you have to be very careful in that too, because I see it all the time. If you have your spouse on or your children on just for the sake of, adding additional people, maybe doing it for estate tax purposes, they too could end up in a lawsuit. So you have to be very careful of who you stick on there. In the LLC, if you recall, if the company is sued, if the LLC is sued, the members and managers themselves don't have any personal liability to the LLC creditors. And then, depending on the state that you're in, is whether or not a creditor can get at the LLC member's interest if the creditor has a personal judgment against them. So what does that mean? There's something called a charging order. And in many states, the charging order is what we call the sole remedy of a creditor against a member's interest in an LLC, and by the way, also in the limited partnership structure and its friends, the limited liability partnership and the limited liability limited partnership. The charging order says if I have a judgment against a person who has an interest in a membership interest in an LLC or a partnership interest in a limited partnership or one of its cohorts, then the only thing that the creditor can get against that interest is the charging order, which means if the company itself issues distributions to the member or to the partner, then the creditor would be able to stand in the shoes of that member or partner and take those distributions. Generally, if you are the person running the company, then you're the one who's going to decide whether distributions are being issued. So if you've got a creditor with a charging order against you, chances are you're not going to send any distributions out, in which case the creditor is just going to sit there and get nothing. So creditors hate charging orders. Not every state is limited to charging order remedies. Some will allow the interest to be foreclosed on. So you have to be pretty sure what rules your state has. You also have to, with the LLC, be conscious of whether or not your state protects the charging orders for single-member LLCs or multi-member LLCs. So some states, for instance, Florida, has become very clear in its law that if you are the single-member owner of an LLC, then if a creditor gets a judgment against you personally, that they do not have only the charging order protection available to them, they have other remedies and can probably take your interest in the LLC and foreclose on it. Whereas if it's a multi-member LLC, the creditor is limited to the charging order. Not every state is clear on its laws. So you have to be kind of, careful to see what your state laws are when you're creating an entity. Keeping in mind that when we discuss jurisdiction, you don't always have a choice of where to create your entity. In terms of, let's talk about the jurisdictions right now actually, because maybe that'll be a little more helpful. When you're creating an LLC, or that's the best choice, LLC or a corporation, you have to look at several things in order to decide where you actually want to create it and where are your options. If you've got an operating business, so I'm going to have a storefront, or I'm going to have a big office with lots of employees, you're pretty much limited to having your entity in the state where you're operating. Now that doesn't mean that you can't create the main entity somewhere else where they have better laws and then register it as doing business in the state where you're actually operating. When you do that, you are subjecting yourself to the state laws, but sometimes you have some extra protections built in certain situations, not all situations, because it was formed in another state. I don't know that I would count on that. You have to be very careful and just be very aware of what advantages there might be. Sometimes it's not enough to make it worth the cost of keeping up both the original formation state and the one you're operating in. If you have multiple locations in your business, you might want to create LLCs in the multiple states. In fact, we'd probably recommend that. You may want to look at what the tax laws are in the jurisdictions. If it's an operating company, more than likely you're forming it regardless of what the tax laws are, you're forming it where it's located. Same for if it's going to own a piece of real estate. Most states require that if you're owning real estate in an LLC, you're probably going to have to register it anyway, so if you form it somewhere else, you'll have to pay for yet another registration. It's probably worth just forming it in that state. Again, you always want to look at the charging order protection in that state before you make a full choice on that matter. If it's something that it's just a holding company, it's really not actively doing business. Let's say it's holding a patent or a trademark or something of that nature, or it's the owner of another company, a corporation or an LLC or a partnership, then you have some greater flexibility of what state you want to set it up in. So when you go to your attorney to make that decision, they're going to base it on what states have the best laws for creditor protection, maybe even what states have the best law for taxes, and also which states are better on visibility. So what does that mean? I live in Florida. If I look something up on the state of Florida website, SunBiz, I can see a tremendous amount about the company and probably about the person who's involved or people who are involved. There are ways to set it up that you can get some privacy, but for the most part, there's a lot of information available online. If you flip that with, let's say, Delaware, where really there's no information available online, Delaware might be a better state for setting something up in. It has great laws, and you can't really see anything. So if I'm general public and I go on the Delaware website, I may see very little about the entity. All I'll see is the name, where it's formed, the date it's formed, and who the registered agent is. Otherwise, I see nothing. And it's very hard for anyone to discover that information. So if you're looking for anonymity, a state like Delaware might be a very good choice. Again, it's all going to depend on, is there operating business? Is there a piece of real estate? You have to evaluate it from both ends. But when you decide on your business, you can potentially choose your jurisdiction. Not always, but sometimes you can. One other way that we can potentially choose some jurisdiction is if we take a company and we actually separate out the different things that it does so that you have multiple companies that are working. So some of them might be able to be formed in one state, others might be in others. When you look for the best type of asset protection, it usually involves layering things. So what do I mean by that? Well, you might say have a limited partnership, and that limited partnership might be good for owning your cash, your savings, maybe your brokerage account, things of that nature. It would even be good for owning as a second layer, owning some interest in corporations, not S corporations, only C corporations, or limited liability companies, or interests that you have in either one of those with other people. So you might use that limited partnership as a top layer. You can also use LLCs layered. You might use different types of trusts involved in the planning. You might, for tax purposes, say ultimately you want things to pass through an S Corp. How do I use my S Corp together with the rest of my planning in order to get good tax benefits? And I would tell you, I can do you one better. How about don't even do an S Corp, do an LLC and tax it as an S Corp, so you can get some great protection under the LLC but still have the S Corp benefits for taxation. So there's a lot of different ways that you can interweave different entities to get the maximum level of asset protection. And if you want to go a step further, then you can evaluate, and again, this is really going to be very specific based upon what assets we're talking about and what type of business and where the business would be operating before you would even consider this. But you might want to consider an international component to your plan and to your business. For instance, let's say my business sits on a lot of cash in the bank. So the business makes a lot of money. We're not distributing out all the money. The business has a lot of cash in its account. Well, if that business gets sued, then a creditor can come and take the cash out of that account. Well, if we don't want to remove the cash from the account to have a creditor not be able to get it, well, we might consider opening up an international company owned by our American company and putting the cash in there. It's completely legitimate if it's done correctly. It's completely up and up with the IRS. And then you're removing that money from where a creditor can really get at it, but it's still an asset of the company. You haven't really changed that, but it's much harder for the creditor to get it. You may actually have a business that has international business dealings, in which case, well, maybe you want to set it up internationally. The things you have to keep in mind, though, are you're a U.S. taxpayer. You're going to pay income the year the money is earned, regardless of where it's earned. You're going to get tax ID numbers with the IRS so they know exactly what you're doing, so that everything is completely transparent with the IRS. But there still might be some sort of benefit for going internationally. You might create an international trust where the trust is an owner or even a beneficiary or the recipient of U.S. earned assets, again, completely on the up and up with the IRS. You have to do everything legally and ethically in order to make this work, but as long as the money is, earned and paid for through taxes and legally earned, there's no reason you can't incorporate an international trust to get some additional creditor protection. Is it for everyone? Absolutely not, but in certain cases you really should be evaluating whether or not there's an international component to your business plan and even to your personal planning. And finally, what I want to tie everything up with is we've talked about the business, we've talked about ownership of the business and where you might set it up and what type of entity you might set up. But ultimately, unfortunately, we're all going to pass one day, and we need to make sure that not only are we dealing with an asset protection level, we need to deal with how our estate is ultimately going to pass when we die. So we might want to have it, again, this is really not every state is popular with the revocable trust, but you might have a revocable trust, which is something you can always change while you're alive, as the top layer of anything you do, because that way you know that ultimately upon your passing, whatever money, whatever assets are going to go through the trust, and you'll have made some really good plans in your trust as to how it's going to pass on to the next generation or to your beneficiaries. You might also consider putting an irrevocable trust in your mix. The irrevocable trust is a little more complicated. It has some tax consequences to it. It does have some creditor protection in most cases, whereas the revocable trust does not. So you might have an irrevocable trust in your mix. And then lastly, we mentioned the family limited partnership earlier, and that family limited partnership was great for asset protection, but it's also a way on an estate tax level of maybe getting a discount on the assets that are transferred into it, which, again, this is a topic for another time, but what you can do is you can reduce the amount in your estate and potentially pay less estate taxes on it if you use a limited partnership, a family limited partnership, and you use it properly. So all these things that we've discussed are great asset protection tools tied in with the estate planning. Everyone should have an evaluation done of all their assets so that they know exactly where they stand and see how an asset protection plan might help them and where it would intertwine with the estate plan. We're going to take a few minutes now to get the questions that have come in. We'll come back in just a few moments and answer them. In the interim, if you wouldn't mind, we're just going to put a poll up just to see if everybody was paying attention. So if you wouldn't mind answering that, and we'll be back in just a few moments. And if you didn't catch it earlier, you can email us at info@assetprotectionattorneys.com.
If you don't keep your asset protection plan current, it's useless. At the Presser Law Firm, PA, we offer ongoing concierge services for your plan with yearly reviews and monthly management to help keep you apprised of updated laws, assist with annual report filing, ensure your financial team is working together, and assist with any of your other asset protection needs. Ask for details on asset protection maintenance when we return to the line. At the Presser Law Firm, PA, we also provide ancillary business services, such as contract and business negotiations, and the preparation and review of business contracts. With lawsuits becoming the next big business, it's important to make sure you know what you're signing, as a lawsuit could cost you tens of thousands of dollars to defend yourself, even if you win the case. To keep you well informed, the Presser Law Firm, PA offers a weekly newsletter and 2 complimentary webinars per month, one on asset protection and one.
Okay, welcome back. We'll take 2 questions. The first question we got, and first let me apologize, we had a little bit of a typo, and on the poll, architect is spelled incorrectly, and we do notice that. First question we got is, well, if I have a retail business, so I have a store, should I own that store in a corporation or in an LLC? The answer is, generally we're much more in favor of the LLC because of that liability protection that we talked about, where it's not only protected for the managers and members if the LLC gets sued, but it's also protected, depending on the jurisdiction, if there's a personal lawsuit against an owner of the LLC, where in the corporation you don't have that protection in both directions. So normally I would tell you it's an LLC. With that in mind, for tax purposes, that LLC, you would talk to your CPA, and that LLC might be best to be taxable as an S Corp. So that's an individual decision. It should definitely be made with your attorney as well as your CPA to make sure that to the extent possible you're maximizing both the asset protection and the tax purposes. Another question is, which entity has the toughest steps to create? Okay, so you can't really answer that question because each one is specific to the state it's created in. So I can tell you that to create an LLC in Delaware might be very quick and easy, one piece of paper. To create a LLC or a corporation or anything else in Florida, you have to, you can do it online, but you have to know exactly how to answer each and every one of the questions in order to do it properly. And it takes a little bit longer. To create it in some states, most of the states at this point are allowing online filing. I can't remember which states are not, but I know for a long time it was difficult to do anything online in Illinois. I believe Louisiana is a little bit difficult. So you have to be sure of, what's the state you must start your entity in. And then, obviously there's some research that needs to be done by the attorney to make sure that, they're filing everything properly, because if it does get kicked back, then, that's a delay in filing. Sometimes there's additional cost. So there's really no direct answer as to which is the easiest, or it's just a question of, knowing what you need to start and, having an idea of how much time it's going to take to create. Like in Florida, you create it online, but it's not an instantaneous filing. It could take a couple of days. At one point it was taking over a week in order to be active. So you need to also have lead time and know that you have the time to spare if you're going to be creating something. Do not wait till the last minute because you can't guarantee anything, and you want to make sure that all your ducks are in a row when you're starting a business. I want to thank everybody for participating in today's webinar. As I said earlier, we do them once a month, one for asset protection, one for estate planning. If you have any topics that you're interested in hearing on either one of them, we always welcome topic ideas. We have our weekly newsletter if you're not already on it. And we do offer complimentary preliminary consultations for anyone who's interested and has a legal question. We'll be happy to do our best to answer it and assist them. So thank you very much for participating, and we'll see you on the next webinar. Thank you.